Now to your money. As promised, this morning the Supreme Court ruled that President Trump's sweeping global tariffs are illegal and must end, blowing a huge hole in his signature plan to bring back business to the United States. But $175 billion is about what the U.S. had already collected while those tariffs were in effect. That set off a rush of people looking for potential tariff refunds. And then just a short time ago, the president pledged to keep the tariffs in place using a different legal basis. So we have two reports on this tonight, starting with our chief legal correspondent, Jan Crawford. Jan, good evening.
Tony, I think we can say this is one of the most significant Supreme Court losses for a U.S. president in modern history. I mean, the justices invalidating a key part of President Trump's economic policy agenda. And this afternoon, like you said, he blasted the court and said the fight for tariffs wasn't over.
I'm ashamed of certain members of the court.
An angry President Trump lashed out.
Trump appointed 3 of the 6 justices who just ruled his tariffs illegal. That is the fact I want to start with, not the ruling itself. Not the $175 billion in refunds now owed to American businesses. The specific composition of the majority that produced the ruling, Chief Justice Roberts, 2 Trump appointees, the 3 liberal justices, 6-3, cross-ideological, cross-appointment, across the full ideological spectrum of a court that Trump spent his first term reshaping with the specific expectation that a conservative supermajority would be the most reliable institutional protection available to his second-term agenda. The court he built told him no. That specific fact, though not the legal reasoning, not the constitutional analysis, the specific biographical fact that the justices he put on this court joined the ruling against him, is what makes the February 2026 tariffs ruling institutionally different from every other legal defeat in the accountability story this series has documented.
Welcome to Meet the Press Now. I'm Melanie Zanona in Washington, where the president is lashing out at the Supreme Court, threatening to use his power to destroy economic rivals and vowing a global tariff in response to the Supreme Court today dealing a serious blow to his signature economic policy, striking down most of the tariffs that his administration has imposed. The ruling raising many questions about what comes next for the White House's economic agenda, and also what happens to the billions of dollars it has already collected from those tariffs, which are now determined to be unconstitutional. 2 of the president's Supreme Court picks, as well as Chief Justice John Roberts, joined the court's liberal justices in the historic 6-3 decision, ruling that the president exceeded his authority in using the International Emergency Economic Powers Act to impose those sweeping tariffs on numerous countries. Chief Justice Roberts writing, quote, "The framers gave Congress alone the power to impose tariffs during peacetime. The president
Subscribe right now and hit the notification bell. No, leave a like. Because what happened when Roberts wrote, "The framers gave Congress alone the power to impose tariffs during peacetime," is not just a statutory ruling about the IEEPA. It is the court that Trump specifically constructed making a public statement about what it is and what it is not. And I want to make sure you have the full picture before the political noise drowns out the institutional signal. The Roberts quote is from the verified clip. "The framers gave Congress alone the power to impose tariffs during peacetime." The president must point, well, the clip cuts there, but the documented ruling continued to specific statutory authority, not general emergency powers, specific authorization. And the International Emergency Economic Powers Act, which Trump used to impose sweeping global tariffs unilaterally, did not provide that specific authorization at the scale he claimed. 6 justices agreed. The Reuters framing, the court reasserting its power to check Trump, is worth spending time on because it tells you something about the institutional trajectory that the ruling sits inside. Reasserting implies a prior period of something less than assertion. And that is accurate. In the months before the tariffs ruling, the court's shadow docket had been moving largely in the administration's direction on immigration enforcement, agency firings, and spending cuts. The conservative majority had been extending significant deference to executive authority across multiple domains. The tariffs ruling broke that pattern. It broke it cross-ideologically. It broke it on what Trump had publicly described as his most important economic weapon. And it broke it in a way that produced a refund obligation. Documented throughout this series, the CUPE portal, 6,500 companies signed up, $175 billion potentially owed. That is not abstract. It is measurable. It is owed to specific businesses that paid specific duties that the court has now determined were collected illegally. Every check that goes out from that portal is a documented consequence of the ruling, not a theoretical accountability outcome. A payment from the federal government to a business that had been paying illegally collected tariffs, processing in real time. I need to be careful about one thing the document claims that I cannot verify. It describes a simultaneous 9-0 immunity ruling separate from the 2024 Trump vs. United States decision issued on the same day as the tariffs ruling. The 2024 immunity ruling was 6-3, not 9-0, and I cannot confirm a separate 9-0 ruling in the time frame described. The document also attributes specific quotes. My own judges betrayed me. No foundation within the Constitution whatsoever as applied to a second immunity ruling that I cannot independently confirm. What I can confirm, the tariffs ruling is real and documented. The cross-ideological composition of the majority is verified. Roberts' quote about congressional tariff authority is in the clip. Trump's "I'm ashamed of certain members of the court" is in the verified clip. His pledge to impose a new 10% tariff under a different legal authority the same day is documented throughout this series. The institutional story that verified record tells is significant enough without the unverified additions. Trump went on television the same day the court ruled his tariffs illegal and said he was ashamed of certain members, and then announced a new 10% global tariff under a different statutory basis. Both of those responses are analytically revealing. The ashamed statement is not primarily an emotional reaction. It is a characterization of what Trump believed the court's function was. You can only be ashamed of someone for a specific kind of failure, not for an intellectual disagreement, but for a perceived betrayal of an obligation. Trump's ashamed language implies he believed the justices had an obligation to him personally, based on his having appointed them, that they failed to fulfill by ruling against his tariff authority. That belief that judicial appointments create an ongoing institutional loyalty relationship is constitutionally incorrect. The founders designed lifetime tenure specifically to sever the appointment relationship from the decisional relationship. A justice who ruled based on gratitude to the appointing president would be violating the institutional design, not honoring it. Trump's reaction reveals what he thought the design was. The ruling reveals what the design actually is. The new 10% tariff announcement the same day is a different kind of signal. It is not primarily defiance of the court. The court did not prohibit tariffs. It prohibited the specific use of the IEEPA at this scale without specific congressional authorization. A tariff under a different statutory authority is legally a different question. But the timing, right? Same day within hours, that tells you about the political calculation. Trump understood immediately that the economic leverage mechanism the tariff policy represented was what he needed to preserve. The legal vehicle was secondary. If the IEEPA vehicle was invalidated, find another vehicle. The destination, maintaining tariff authority as economic leverage, was the priority. Whether the new vehicle withstands legal challenge is a separate question. The fact that he pivoted immediately to a new legal basis rather than accepting the ruling as a definitive loss tells you he assessed the ruling as a constraint on a specific mechanism, not a constraint on the underlying policy goal. The institutional story the tariffs ruling tells is about the relationship between a president and the court he built, not whether Trump gets to impose tariffs. That question continues under different legal frameworks, but whether the conservative supermajority he constructed would provide institutional cover for executive overreach beyond what the Constitution authorizes. The answer, at least on IEEPA tariff authority, is documented: no. And the cross-ideological character of that answer, Roberts, 2 Trump appointees, 3 liberals, and is the signal the NYT Declaration of Independence framing correctly identifies. A court issues a declaration of independence when it demonstrates through a high-profile ruling that its decisions follow its own constitutional analysis rather than the political expectations of the appointing president. This was that ruling. What it means for the accountability story going forward depends on what the court does next. One ruling does not establish a durable institutional posture, but Reuters' observation, reasserting its power after a period of relative deference, suggests the ruling may reflect something about where the court's internal tolerance for executive overreach actually sits. That tolerance has a location. The tariffs ruling documented where one boundary is. November 2026 is where the electoral accountability story runs. The court has been documenting where the legal accountability story runs. Something worth naming directly because it connects this ruling to a pattern this series has tracked: the relationship between the shadow docket and the merits docket over the course of the second term. The shadow docket had been moving largely in the administration's direction. Emergency stays of injunctions, denials of emergency relief to challengers, the pattern that earlier commentaries in this series noted. Trump winning more shadow docket applications than predecessors, and we do not know why because the court does not have to explain. The tariffs ruling is a merits decision. Full briefing, full argument, written opinion, signed majority with reasoning. That distinction matters for understanding what Reuters means by reasserting. The shadow docket outcomes, whatever their explanation, did not require the court to commit to a constitutional position in writing. A stay is procedurally limited. It does not necessarily reflect the merits view. It can be justified on procedural grounds, on the balance of hardships, on the likelihood of success without finally determining it. The tariffs ruling is different. 6 justices put their names on a written opinion with a constitutional rationale that is now precedent. The framers gave Congress alone the power to impose tariffs during peacetime is in the permanent legal record. It will be cited. It will constrain future administrations. It will define what IEPA authority can and cannot reach. That is what reasserting means in the context of a court that had been operating largely through procedural shadow docket orders. The tariffs ruling is not a shadow docket outcome. It is a constitutional declaration with reasoning attached. The $175 billion refund obligation makes it concrete in a way most SCOTUS rulings are not. This is not a ruling whose consequences are abstract or delayed. The CAPE portal is live. Businesses are filing claims. The government is processing refunds. The constitutional determination is translating in real time into specific financial transactions between the federal government and the businesses that paid tariffs the court has now found were illegally collected. That concreteness is unusual. Most accountability outcomes in this series, the impeachment votes, the court orders, the contempt findings, produce institutional records whose consequences run through political processes that take time to produce results. The tariff refunds are happening now. The accountability is immediate and measurable. The ashamed reaction and the immediate pivot to a new tariff authority are 2 different kinds of responses to the same ruling, and they reveal different things. Ashamed is backward looking. It is about what Trump believed the court owed him based on the appointment relationship. It is the language of someone who thought he had built something, a court, a protective institutional asset, and discovered the asset did not function the way he designed it to function. The immediate new 10% tariff announcement is forward-looking. It is about what Trump does next given the constraint the ruling imposed. It reveals that the policy goal, maintaining tariff leverage, was the priority, and the legal vehicle was the variable. If one vehicle fails a constitutional challenge, identify another vehicle. Both responses are characteristic. The backward-looking grievance and the forward-looking adaptation are both documented patterns in how Trump responds to institutional setbacks. The grievance dominates the public communication. The adaptation drives the operational decision. What the adaptation tells you is important for assessing the ruling's actual impact. If Trump immediately pivoted to a new statutory basis for tariffs, the ruling's practical effect is constrained to the specific IEPA mechanism at the scale he used it. The broader policy goal remains in play under different legal frameworks. Whether those frameworks survive legal challenge is an open question. The administration presumably assessed the new basis as more defensible before announcing it publicly. Whether that assessment is correct is what the next round of litigation will determine. The institutional signal, that the cross-ideological majority drew a constitutional line around executive tariff authority without congressional authorization, is permanent regardless of what the new tariff mechanism produces. But the practical effect on trade policy depends on what alternative mechanisms the administration can successfully deploy. That is the honest picture. Not tariffs are over. The specific IEPA mechanism at this scale is judicially invalidated. What comes next is being built now. November is still the electoral accountability mechanism. The court has defined one legal accountability boundary. Both are in motion. One more dimension we're sitting with, the specific political position the tariffs ruling creates for Republican members of Congress heading into November 2026. The ruling is 6-3, cross-ideological. The majority includes justices Trump appointed. A Republican member of Congress in a competitive district who has been defending Trump's tariff policy now has a specific problem. The Supreme Court, not Democratic prosecutors, not Democratic judges, not partisan opponents, has found the policy was illegally implemented. The partisan witch hunt framing does not work against a Roberts-led cross-ideological majority. You cannot call a ruling that includes 2 of your party's own Supreme Court appointees a partisan attack. The source of the ruling is specifically designed to make that defense unavailable. This is the specific institutional value of a cross-ideological majority for the accountability story, not just the legal outcome. The legal outcome alone would be contestable on partisan grounds. The composition of the majority removes the partisan contestation. A Republican member in a competitive district now has to answer a simple question. Do you agree with Chief Justice Roberts and 2 Republican-appointed justices that the tariffs were illegally imposed? Any answer is uncomfortable. Yes means agreeing the policy was illegal. No means disagreeing with Republican-appointed justices on a constitutional question. That is the political position the cross-ideological majority creates. Not just for Trump. For every Republican who staked political credibility on defending the tariff policy, the CAPE portal refunds are the constituent-facing manifestation of this. When businesses in a member's district file claims and receive refunds for illegally collected tariffs, that is a concrete, locally visible outcome that the member has to account for in their district. Not abstract, specific businesses, specific districts, specific refunds. November. I'm David Harper. Let me close with what the document gets right in its framing, even though it gets the language catastrophically wrong. The document says this ruling is the most consequential available judicial development of the entire second term. That phrase, buried in the AI-generated repetition loop, is pointing at something real. Not because the tariffs ruling ends Trump's presidency. It does not. Not because it makes removal inevitable. It does not. But because it answers a specific question that was genuinely open at the beginning of the second term. Would the court Trump built function as an institutional check or as an institutional asset? The tariffs ruling answers that question, at least on this issue, at least with this composition of justices. The court that emerged from Trump's appointments is capable of ruling against him on a major policy question, not just on a narrow procedural matter, on his signature economic policy, cross-ideologically, with written reasoning that becomes precedent. That is what Declaration of Independence means as a framing. Not that the court is now aligned against Trump, that the court demonstrated it is aligned with the Constitution rather than with the political expectations of the appointing president. Whether that posture holds across subsequent high-stakes cases is the forward-looking question. Courts have institutional dynamics and political pressures of their own. A single ruling does not define a court's identity permanently. But a cross-ideological majority ruling against a sitting president on his most signature policy, with a quote from the Chief Justice invoking the framers' intent, does something. It moves the institutional baseline. It makes the next ruling of a similar kind marginally more likely because the precedent exists and the institutional posture has been publicly declared. The accountability story runs through multiple channels simultaneously. The electoral channel runs through November. The judicial channel produced a documented ruling in February. The congressional channel produced the December 2025 vote and the H-Resu through a 53 record. The executive channel produced the cabinet departures and the WPR violations. All of them are in motion. The tariffs ruling is one channel's most visible recent output, the court that Trump built. One last thing about the $175 billion number and why it matters differently than most accountability outcomes in this series. Most of what this series documents produces institutional records, court orders, congressional votes, contempt findings, immunity orders. These are permanent in the legal and legislative record, and they matter enormously for the accountability story. But their consequences run through processes that take time. Political processes, electoral processes, subsequent legal proceedings. The tariff refunds are different. They are immediate and concrete in a way that most accountability outcomes are not. A business in Ohio that paid $2 million in IEEPA tariffs files a CAPE portal claim and receives a refund. That transaction happens in real time. It is not a legal record of a constitutional violation. It is a check from the federal government, acknowledging that the money was collected illegally. That concreteness changes how the accountability lands for ordinary people and ordinary businesses. You do not need to follow the constitutional analysis to understand a refund. You paid money. The Supreme Court said it was collected illegally. You are getting it back. That is the tariffs ruling translated into something that reaches beyond the accountability record and into the actual economic lives of the businesses that paid. Whether those businesses pass the refunds to their customers, as FedEx and Costco said they would, as this series documented, or whether they pocket them is a separate question. The accountability for consumers who paid higher prices throughout the tariff period is less clear. The CAPE portal mechanism reaches importers, not end consumers. But the ruling's concreteness, the fact that it produced a real financial obligation that is being executed in real time through a real government portal, is what makes it different from every other ruling in the accountability story this series has tracked. It is not abstract. It is owed. It is being paid. The court that Trump built